Hello, my name is Nia Fonville, and today myself and my colleagues are pleased to present this presentation on exclusionary lawyering, how to build rapport and recover from blunders. As I said, I'm Nia Fonville, and I am the Director of Externships at Campbell Law School. I also serve as the chair of the Pro Bono Committee's Diversity and Inclusion Subcommittee. And I'm joined today with two of my subcommittee members, and I will allow them to introduce themselves.
Hi, everyone. I'm Nisel Desai. I'm an associate attorney at Carnes Warwick, and I'm excited to be here with you guys today.
Hello, everyone. My name is Fran Muse. I'm the director of Carolina Student Legal Services. We're a nonprofit law firm on the UNC campus for UNC students. And I'm also happy to be here today and be a part of this presentation.
So as I mentioned, we're going to be talking about inclusionary lawyering and providing some tips on how to build rapport and recover from when we make mistakes. While our program is really geared toward pro bono attorneys, it is our hope and our suggestion that you find ways to incorporate these tips in any type of legal practice you may have. For today, we hope that after our session, you'll leave with 3 takeaways. Number 1, you are able to identify subtle acts of exclusion that may occur as you engage in pro bono work. Secondly, you have some tips on how to build rapport quickly with your pro bono clients. And finally, you understand some tips on how to successfully recover from mistakes that you may make. We've all had training sessions on unconscious bias, microaggression, so I'm not going to belabor the point of what these items are, but just we're going to have a little revisit of microaggressions. I like to refer to them as subtle acts of exclusion, but you also hear them microaggressions and micro inequities. For the purpose of our discussion today, we're going to use the definition as the everyday slights, put downs, and insults that minoritized people experience in their daily interactions. They're often linked to our implicit biases, occur outside of our conscience, and may be unintentional. So just as an example, we see you were born in Canada. So that seemingly harmless question really goes at really questioning someone when they say, when you say, hey, where are you from? And I say, I'm from Canada. Wait, really? Because unconsciously, you may associate this character as not the stereotypical Canadian that you envision. The other example I have is something when we're talking about individuals with disabilities. You have a disability, you seem perfectly normal to me. So just thinking about how that might feel if you are on the receiving end of that kind of statement, which is seemingly harmless. As we move through today's discussion, I want us to think about the various categories that micro inequities or subtle acts of exclusion may present themselves. So these might be comments or behaviors regarding race, ethnicity, socioeconomic status, age, gender, gender identity, sexual orientation. It might even include religion. And this is not an all-encompassing list. As pro bono attorneys, we may find ourselves engaging in pro bono services in a myriad of areas. Some of the common areas that maybe your pro bono projects might be in, or in your own forms of organization, surround criminal law, domestic violence, protective orders, driver's license restoration, housing, foreclosure, bankruptcy, advance directives, and general civil issues. Prior to transitioning to higher ed, I was a legal aid attorney for a little over 10 years. And so what I want to do is spend a few minutes to use my experience to share with you some instances of how I think these subtle acts of exclusion may manifest in your pro bono work. And I'm using my experience with some of the populations that pro bono attorneys serve. I am a firm believer that it all starts with hello. As an attorney, I prided myself on the way I built rapport with my clients. And I think that one of the main ways you build rapport is that initial client meeting. And when I talk about starting with hello, that just refers to saying my name. When I introduce myself to a client, I say their name. And I say it without commentary. So sometimes people will say my name and they might say Naya. And I'll say, oh, well, it's actually Nia. Individuals who may mispronounce, it's great to just say, you know what, I'm sorry. I'll correct that, Nia, and then continue. But I've had individuals who will make comments about, really, that doesn't look like Nia, or shouldn't it be spelled N-I-A? So we're just talking about saying a client's name without remarking on how unusual it may be to you. We've also, sometimes people may ask, well, is it okay for me to ask how to pronounce it? And I think the answer is it depends. Do you find yourself asking only those individuals that you're unfamiliar with? Perhaps a way you could do it is give it a try. Say the name, allow the client to correct you, or sometimes look at their body language. I know I find myself not correcting everyone, but maybe if you look at the body language and you say, you know what, I'm sorry, did I mispronounce that? You don't have to make it too big of a deal. So now once we get past hello and we're into the actual representation of the client, we might see that there are some language barrier issues. And these language barrier microaggressions, they can be actual or perceived. And two examples that I can think of is perhaps you have a domestic violence client who has a hearing impairment, and so you are using an ASL interpreter. But you find yourself, you are actually talking to the interpreter, looking at the interpreter instead of the client. That is a microaggression that I am willing to bet it's unconscious. The same thing might go if there's a Latinx client that comes in with her daughter and you're using a translator, but the translator, you're doing the same thing, looking at the translator as opposed to looking at the client. Or you might, while looking at the translator, you're speaking about the client as though she's not there. And an example of that is if you're saying, I want you to ask her X, Y, and Z, or what did she do then, as opposed to saying, Miss Jones, what happened after the landlord cut your lights off, whatever it is. So here, that's an actual, but a perceived language barrier can come into place if same client with her child, you go up and immediately speaking to the child as though you assume that the parent does not speak or understand English. These are things that may slip up on us. And one suggestion there may be that instead of having the interpreter or the translator in front of you, have them sit beside you. That way you will be forced to look straight ahead and engage with your client. Another identity that we talked about in our list to be mindful of is socioeconomic status. And I think what I have seen is that sometimes our behavior presumes either guilt or a lack of entitlement. This I've seen in the landlord-tenant arena. So let's say you're helping someone with a landlord-tenant case, an eviction case. You get the complaint and the complaint says that the landlord alleges your client did not pay his rent. You have to be mindful of your attitude, the way you ask questions to the client, the way you speak to the client, so that your attitude doesn't reflect one that automatically assumes that either the client did not pay his rent or had no legal right to withhold his rent. The other areas you may see this is if we're helping with bankruptcies or foreclosures. I've seen instances where attorneys are assisting with loan modifications. So you're assisting the client to apply to have a reduction in their mortgage so that they can save their home out of foreclosure. But part of that process requires you to develop a budget with the client. So you may see things, entries for internet or cable, and be mindful of not making comments about, well, these are just luxuries. You don't need these. Sense of entitlement. Or, and I think about in the religious sector, if you see tithes or contributions to some type of house of worship, you have to be mindful not to automatically say these are luxuries, because you don't understand, or you may not fully understand what someone's religious beliefs mean to them. Another area is the area of cultural norms and negotiating settlements. And here I've seen the example of the individual thought and approach to decision making versus the community. And I'm reminded of a Hmong client that I had, and we had worked on her case, reached what I thought was an amicable resolution based on her stated goals and desires. And she made the comment, you know, I really need to speak with my eldest brother first, my oldest brother and my father. And I had to work on understanding that, yes, I recognize that she is the client, the rules of professional responsibility identify her as the client, but for her, there was a cultural norm attached to birth order and the respect and the obligations of that eldest brother. And once I realized that, I was able to increase the effectiveness of my representation to her. Another area that we don't have mentioned here, but I do want to point out, is remember age. And many of us engage in advanced directives, the will clinics from various pro bono groups and associations. And so thinking about how you engage with those clients. What about the level, the volume of your voice? Don't automatically assume that an older adult client has a hearing impairment. In the same vein, be mindful of the way you speak to them, using childlike conversations or speaking to them as though they are children. It's dehumanizing and disrespectful and rude. So I'm hoping that as you engage in your pro bono work or even your own client work, you are mindful of how easily sometimes these subtle acts of exclusion will pop up, and you be committed to correcting them. So now what we're going to do is we will move into building rapport.
Hi, everyone. I'm by no means an expert in this area. I have had the privilege of serving a very different or diverse type of clientele through both my practice and pro bono work over the summer in helping protesters resolve their misdemeanors at Wake County District Court. Can I get the next slide? So let's start with the why. The ABA Standard 2.4 on cultural competency for civil aid providers. Let me read the standard to you. A provider should ensure that its staff has the skills, knowledge, and resources necessary to provide assistance in a culturally competent manner. The commentary further states, to be culturally competent in legal aid means having the capacity to provide effective legal assistance that is grounded in an awareness of and sensitivity to the diverse cultures in the provider's service area. A cultural group is identified by shared beliefs, values, customs, and behaviors that define what it is. Part of this really requires changing your own mindset and realizing that your experiences, your beliefs, the categories that you fit into, they are just as very much making you an other to everybody else. And this shift away from heteronormativity or cis normativity, all of those shifts really are what you should walk into in a pro bono interaction with to signal inclusiveness and sort of be ready and accepting. Can I get the next slide? The difficult part about this is the pro bono transaction is really quite truncated. You have a clinic, you might have one or two follow-ups, but there really is sort of that lack of instant gratification in that you might not have an immediate result for your client. This is also even more critical in terms of the fact that you have very few opportunities to signal openness and inclusiveness when a client comes through. There's two ways to signal this to potential clients. The first is using ADA compatible materials, whether it's on your website, your marketing, your intake materials. Furthermore, in your intake materials, be mindful of inclusive language, such as asking what a preferred pronoun or a preferred name is, because often there are certain subsections of the population where those things might be quite different from another, and it never hurts to ask. And it goes a long way in showing that you're accepting people for who they are. Once again, this is truly just a matter of meeting people where they are. We're not forcing any political agendas, and it's done to preserve human dignity. So once you're in the appointment, I strongly recommend effective interviewing skills. Everyone, everyone feels like, oh, I'm an attorney, I'm a counselor, I can do this, I've done this for a long time. It's always worth brushing up before you're interacting with populations that you might not have before. Mirroring, nonverbals, these things can go pretty far in communicating that you're competent, at least emotionally competent. So I suggest that you let the client lead in terms of your nonverbals, though, because of cultural differences that might manifest. Some people may be more expressive with their hands. Others may want a certain distance from you. Let the client sort of dictate how comfortable they are in this interaction. I also recently attended a training with Ellie Krug, and she told us to sort of reframe all of our interactions as dealing with people who are experiencing the same human condition that we are, one that can be difficult, and we all sort of have the same three ultimate needs at the end of the day. And prioritizing this human dignity really is going to go a long way in improving your pro bono relationships. And secondly, commit to educating and advocating for your client. Remember, there are going to be non-NCBA personnel at clinics, whether it's a bankruptcy judge or a FEMA agent, occasionally the National Guard at some of these, and they might not have the same level of training or inclusiveness or accept it or be as accepting of minorities as we all are inclined to be. In that case, be prepared to do some education, and there might be some risk taking involved, and you're definitely going to feel out of your comfort zone. But remember that you're doing this as part of your commitment to be a zealous advocate to your client. Thirdly, and I think this could make huge strides because it's showing a visible investment in resources to signal this openness. Commit to inclusive staffing. This goes to the use of legal translators who are present at the events. And it's critical to use a legal translator because as attorneys, we're in a technical field. We feel that we're the ones that are the holders of knowledge. We speak a very distinct language in terms of vocabulary with each other. And using these terms and using these jargon with even an English speaking client can sort of be alienating. Once you introduce another language into that dialogue, it takes it a step further in building another bridge between you and your client. So having translators that can break down the legal knowledge into something that doesn't get lost in communication into another language is absolutely critical. Another important aspect of inclusive staffing is the use of non-legal professionals that are well-versed in mental health and social work resources. They're absolutely able to, discuss things with your client that may not come up with your own appointment, but it really goes to this idea of whole person and holistic lawyering. Could really make a huge difference in terms of helping a family find housing or impact an entire generation if you're able to set them up for success. And lastly, cultural norms and stereotypes. It's very easy to go through certain client counseling books and sort of see where they categorize certain populations. Don't let this list sort of drive the interaction. Just be aware that there are certain tendencies, such as a lean towards individualism versus collectivism and other habits that are part of one's culture. Be prepared to identify them and then respond appropriately. And lastly, I leave you with a little bit of homework. Take the Harvard Implicit Association test with a colleague. Choose two different categories from people that you normally wouldn't interact with, and discuss the results. If you're finding that you're vulnerable or maybe even a little bit ashamed, it's okay. Process the results together, discuss them, do the work, and hopefully this will reframe the narrative that you walk into your next pro bono appointment with. Thank you.
Hello, everyone. So as I said earlier, I work with Student Legal Services, which is on the campus of UNC Chapel Hill. And when Nia approached me about being a part of this presentation, I thought, I don't have any special knowledge about this. I'm not an expert. And then it, immediately occurred to me that I do need to have some special knowledge about this. I work on a university campus where we value diversity. We want all of our students to feel safe and to feel welcome. And so it immediately became obvious and important to me that I do need to be a part of this and educate myself about this important issue. Also, because I work on a university campus, I have access to experts that have special knowledge about these topics. And I reached out to one of our experts on campus, Dr. April Callis, who is Assistant Director of the LGBTQ Center. Now, there are times that when we make these blunders that we can self-correct, right? As Nia pointed out earlier, if you find yourself looking at the interpreter instead of the client, reposition yourself, try to self-correct when you can. But when you can't, Dr. Callis gives us 3 strategies that we can use to recover from blunders. The first one is don't get defensive. The second one is apologize. And the third one is don't make it about you. So let's talk about those for a second. When she says don't get defensive, what she's telling us to do is not to start explaining why you made this remark. Don't try to justify your words. Recognize that a good ally prioritizes the impact that our words have rather than the intent. And Nia talked about that earlier. What do we mean when we say that intent does not equal impact? A good example of that is like if you unintentionally hit someone with your car. It wasn't your intent to cause harm to that person, but certainly the impact of your actions did. So just recognizing that when you're in these situations, try not to get too emotional or defensive. Perhaps you're having this conversation with a family member, or you're in a workplace situation and you're embarrassed and don't know how to react. Dr. Callis says, just to apologize, say, I'm sorry, thank you for telling me, and then take some time to think about it. This gives you an opportunity to leave and think about what happened instead of getting defensive in that moment. Apologize. This is easy. Dr. Callis tells us to just own up to it, say, I'm sorry, and I'll try and do better in the future, and then to educate yourself to do better. As Nisel said earlier, do some homework and practice. When it comes to practicing with or using good pronouns or educating yourself on pronouns, a good website is practicewithpronouns.com. Dr. Callis also tells us to, take some time if you're in the car, for example, to have a conversation with this person and to practice having a conversation using different pronouns. So really take this opportunity to educate yourself so that you will do better in the future. And the last thing she tells us to do is to not make it about you. Don't start apologizing profusely and making the person, the recipient, feel bad about what you said and putting the pressure on this person to make you feel better about what you did. The moment shouldn't be about making you feel better, but making sure that the other person is feeling like you heard them and that you recognize the impact that your words has had.
And today you've heard quite a few times, especially with Fran's presentation about the importance of not relying on your intent, but rather focusing on the impact. That's how we also remove ourselves from the center of attention, by relying and focusing on that impact. And so for us, the bottom line is, yes, we're being kind, but being intentional. Intentionality around our preparation for cases, the same way you're going to study the law, read new laws or statutes. You must be intentional about building and maintaining your relationship with your client. It is our position that inclusionary lawyering is integral to you making sure that you are a competent attorney. And just remembering, intent does not equal impact. For far too long, we've allowed both ourselves and other individuals to use the fact that I didn't mean harm as a crutch. And we can no longer do that. So we challenge you to be willing to put in the work so that you are an inclusive attorney, so that you build rapport with your clients, and that you then in turn are able to effectively represent them. Thank you.